Hey, it's your old buddy Brian Parker with another exciting video. Why is it exciting? Because this is a sort of a David and Goliath story. I have a member that used our techniques and forms on killdebt.com and is showing me what they're doing. So I'm showing you what they're doing and how easily it could be done. So I'm titling this, How Jack Crushed Citibank's Lawsuit and how you can win too with killdebt.com. So first, of course, you get that lawsuit, you have your pity party, 5 minutes, now come out swinging. And you come out swinging the same way Jack did. Here, the complaint against Jack was a easy peasy, no care in the lawsuit that you see 9 times out of 10. 9 times out of 10, most collection lawsuits are defaulted or easily settled for bad deals for the person that's scared and being sued. So 9 times out of 10, those lawsuits are going to win as far as the debt collector is concerned. So they don't put any care into their work. Well, if you are a disciple of my self-defense website, you know all the ins and outs, the crooks and crannies and behind the curtain stuff where you can prevail or get that settlement you want. And so does Jack. So here first is the complaint against Jack, Shazam. And you can see right there, he tore it apart the same way I describe in some of my creditor examinations or creditor videos. Take a look. Here, they're talking about what a loan account is, and he points out, and you should do this. I'm going to start doing this. This is fantastic. This is all Jack's work, not a loan account by definition. They talk about an agreement. He points out to the court, no agreement attached. Oh, this is beautiful. It's in South Carolina, and in South Carolina, the debt collector or anybody that's seeking a debt repayment has to give you a right to cure. And they are claiming the notice of the consumer's right to cure went out. Well, he knows he didn't get it. So he denies this, as he states in his affidavit. And he's thinking like an attorney. Now, by the way, Jack is a salt of the earth, regular guy that climbs telephone poles and fixes telephone wires for a living, but with an active brain, and he uses our site. He's had a number of cool successes. So as you can see in number 5, they use the word may. It says the business transaction described herein may be, and the word is spelled wrong, may be a consumer credit transaction as contemplated by the South Carolina Consumer Protection Code. So he writes may. Well, is it or is it not? I mean, it's snarky, but it's based upon their vague, improper language that doesn't mean anything. So he's allowed to call them on their stuff. So that is how a regular guy, Jack, tore apart their complaint. They have an affidavit against him. So let me put you the affidavit up against Jack in the lawsuit against him from Citibank, Shazam, and there he is, he's at it again. He's circling with that beautiful red pen. The attorney can't swear to this, even though the attorney is swearing to this. On the bottom it says plaintiff, defendant, or his attorney. So he writes, rightfully so, well, which is it? You got to specify. And then he points out again, attorney can't swear an affidavit. He's no personal knowledge. And he's correct. He's just, okay, here's another one, here's another one, here's another one. There has to be some better proof that the attorney has the right to do that. Normally you don't have an attorney signing the affidavit that he's also signing of a lawsuit. But again, there's no care a lot of times put into these complaints, and you can take advantage of that. So Jack came back with a counter affidavit. And because he's a disciple of this self-defense website, Shazam, there's the first page, Shazam, page 2. So I highlight, he specifically makes sure the court knows, I do not owe this debt to defendant. And he's using what he learned from our site. This is an attempt to collect the debt, and any information obtained will be used for that purpose. It's on the lawsuit, so it is a collection communication. What else is it? It literally says, this communication is from a debt collector. So if that's on one of your creditor lawsuits, they can't wiggle out and say, well, we're creditors, we're not subject to the FDCPA. So that's the point. If you're subject to the FDCPA, then you have to follow the rules, and it's unlikely you do in a debt collection scenario. So if you're a creditor, you say, oh, no, I'm a creditor. We aren't governed by that. But if they're using the language and they can't say, yeah, our attorney put that on, the attorney is an agent of the party, which in this case is Citibank. So on the second page, he said, this word debt is not in the complaint, just the word account. I did not receive notice of the consumer's right to cure pursuant to South Carolina code. So he goes in hard on that. And that's a cool thing that South Carolina has. And I don't know if you've noticed, but everything he sends to the court and to the other side, he notarizes. So that's an indicia of reliability, as they used to say in evidence class in law school. He's supporting what he's saying by a notary. You don't have to do that. And I've showed you ways that you can avoid doing that. But he did it. That's, you know, belt and suspenders. So here's a couple of pages of Jack's answer, okay? So he did that affidavit. He tore apart their stuff. And as I always say, you use their documents against them, put it in your counter affidavit, that creates your answer. Let's look at the first page one of his answer, Shazam. And he's going right in for lack of standing on the preliminary statement. Remember, there's really no requirement of a preliminary statement, but there's no rule that says you can't have a preliminary statement. That's Parker's brain. So lay it out for the court. In a sense, you're doing the court a service because she's got tons of cases, in, out, in, out, in, out. Now someone's explaining what this is all about, and you get to say your side of things right at the preliminary statement, and he says 3 words. I mean, and that's the power of, if you can get that brief, concise statement that envelopes everything that your case and defense is about. Lack of standard. Color me interested. So now the judge is on, what is he talking about? And he lays out the 10K securitization, Securities and Exchange Commission report on Citibank, how it securitizes all its debt. There's at least 2 owners now, the trust and partly Citibank in some cases. Sometimes they give it to them all. But even if they've given it to them all and there's a default, the trust must return it with the pooling and service agreement explaining that. So you can see on page 1, big words. Credit card securitization. This company securitized credit card receivables for trusts established to purchase the receivables. All about leverage. Load that puppy up with something where the debt collector is just saying to himself, I don't need this. I want to work a 9-to-5 job, have my bourbon at 5:15. I don't need this. So that's leverage. But it's also the truth. It's also your right to have a good faith defense, which normally isn't the case unless you're in the 10% of that poor statistic that 9 out of 10 collection lawsuits go south or default. Look at page 5, Shazam. He goes in again, number 20. Plaintiff states it sent a notice of consumer's right to cure in line 8 of its complaint. Defendant denies this. Defendant did not receive a notice of consumer's right to cure as required by South Carolina law. I'm going to show you why he's going hard in on that. He also did as I advised, but I don't tell you how to live or law. He sent the securitization letter. Shazam. That's his letter. He pulled it off our site. He's a member. He's entitled to everything he wants on that site. And he wrote them a securitization letter. So he's belt and suspenders. He says it. He explains it. He shows it. That's the key to even if you're having an argument with someone. Yes, you did. Yes, you did. And here's where you signed. And that's court. Court is just about relationships and communication. The better the communication, the better the relationship. So if you can have a relationship with the court showing, look, I'm communicating exactly what they did wrong here, you're in great shape. The other attorney is going to be like, securitized what? That'll come through. So Jack came through. He also has affirmative defenses up there. They failed to state a claim upon which relief can be granted, meaning that they don't have standing. There's no payment or agreement between the agreements. There's no agreement, yet they're filing a breach of contract against him. What contract and what terms and conditions? The important point here is Jack took my brain and said, yeah, just say it. Just say what they didn't do or what they're doing that is wrong. Don't be afraid. Have your 5 minutes. Oh God, I've been sued. I've been there. Now come out swinging. There's no reason why you have to put up with any nonsense. So Jack did what I talked about last week when I talked to you about the third-party complaint, the cross-claim, and the counter-complaint. Jack counterclaimed. And this is what he did, and this is great stuff. I'll put up what he did. Shazam. Under the FDCPA, he said, and this is what I've talked about this in the past, 1692E2A is my favorite section of the FDCPA. Citibank is suing with no proof of ownership, so they legally can't sue. It can't make false statements about the character of the debt, legal reason to sue, or the amount. The threat to sue him when they don't have a right to is E5. E10 is your panacea or all around, hey, they misrepresented the law and the facts. And as we point out, it's a strict liability statute. You just have to show a violation. You don't have to go prove it in some cases. And then he threw in, as he showed, this is all his stuff, by the way, 37-5-108 bans any false, misleading, and unconscionable collection act. He said they 37-5-110, they skipped the 20-day right to cure. You can see them not having time to send out thousands of these right to cure letters to the wrong address, you know, because this debt's been going on. You can see how they're just saying, forget it, because we've got 9 out of 10 are gonna just roll over. Why do the work? So what does that get him? So he filed that answer that was chock full of stuff. And remember what I said about counterclaims. You really have done all the work with the answer and the counter affidavit. It just goes up in the air and plunks right into your now allegations as you're suing them, putting them on their heels. And that gives you, let's put it up there, Shazam, payoff and leverage. Counterclaims flip the fee shifting script and the case. Now Citibank's on the hook. Now this is, relatively speaking, a low amount. And it is all about how much is the Citibank attorney going to invest to chase something that's nuisance value and be subject to a lawsuit if he's wrong. They're going to get this case settled. That is leverage. And then a small thing that I threw in by counter, let me put up the counter affidavit, counterclaim video. And there's the cross-claim video, and there's the third-party video. I like to do that when I reference something so you can go and go look for these. So those are great things. So, okay, go away. The counterclaim video, I made a throwaway there. I think I did it in the cross-claim possibly too. When you do a federal act, so I'm counterclaiming against you and I'm alleging you violated federal law, there's some ways that they can just say, oh yeah, well, we're taking that to federal court because you have what's called a federal question. They've got 30 days to remove or they lose the right. So what he did, as I counseled, especially in my cross-claim video, I said, bring it all at once. And he did that. He filed the answer and the counterclaim, just threw the kitchen sink at them. Because he had a good faith reason, you can tell just from, and that's the point of those red lines. He's pointing out where they factually and legally went wrong. That's a strong basis for an FDCPA claim on whatever the state act that you're in. Some states are good, some states aren't so good. What Jack did is he piggybacked the Consumer Protection Code. For example, Michigan has a Fair Debt Collection Practice Act federal, a Michigan Collection Practices Act, and a Michigan Consumer Protection Act. And he also has a Michigan Occupational Code. So there's 4 ways you can go after. Some states you don't have enough to go after, or you have to, what Jack did is piggyback on the consumer statute. So that's what Jack did. And how he built it is he used all the information against Citibank, American Express, BOA, you name it, we've got it. Every creditor, we've got a lawsuit that's been filed that we defended against. We've got all the templates, and he took the templates and did it and used it. You can specifically see some of the stuff that's coming off my site. He built the FDCPA counterclaim. He used the documents. He used what I call the combo. He did the answer and the counterclaim combo. And then he used our cheat sheets to create a counter affidavit, an answer, and a counterclaim. And now suddenly Citibank's on its heels facing his lawsuit. And it's sort of embarrassing when if you will, I can't say this any better, and it's good. A gentleman like Jack, who works for a living, climbs those poles every day, fixes those wires so we can communicate with everybody. That's hard work. You're up in the sun. Right now it is. And here's this salt of the earth guy smacking an attorney. There's some coolness in that. Citibank suddenly faces a whole world of problems. And now he's waiting for that securitization letter results. He's going hard in, and now the judge is fully educated with that preliminary statement on the answer. So your next step, if you want to be in great shape like Jack and create the leverage, go to killdebt.com, and remember, oh, you know what I'll do? I'll put all of Jack's stuff that he's given me online on killdebt.com in Word. So if you want, you can use his stuff that's based on my stuff for your stuff. All right? And also don't forget, middle of June 2025, we're on track. Killdebt.ai. The AI is coming whether we like it or not. So I thought, how can I use that to help my clients? So I've set up and created, or we're creating a platform that will be part of the site very soon, where you can do what Jack did just by feeding the machine, if you will, all your information, and up pops all that stuff that I just gave you, done for you. So Jack did it all on his own based on our templates. You wouldn't need the AI to still successfully use our site. This is just another easy way I'm producing something so you can self-defend easier, so you can manipulate the paperwork without having to type everything. It's going to be great. Killdebt.ai. It's, again, coming in June of 2025. I'm so excited. I'm up nights thinking, how can we do more? What can we do? And this is my next thing, this next iteration of doing the best for you to fight back against those bad guys. I always talk about that 9 out of 10, how unfortunately 9 out of 10 statistically, and different states, different rates, but statistically, 9 out of 10 people just fall on their sword or make a bad deal or don't do anything with the debt collector. And the debt collectors are banking on you sticking your head in the sand. I have been in every level that you have, of every situation financially, all that stuff. Not exactly, but maybe you haven't been as hard pressed as I've been, but I've been there. You want to stick your head in the sand. Don't. If you want, do it for 5 minutes, then come out swinging, right? And let's go get these bad guys and do what Jack did. Use killdebt.com and rock this. Thank you.